All right, guys, we're going to go over some worksheets on the Supreme Court and how the cases heard by the Supreme Court ultimately set the precedence of how future cases, similar cases, would be heard by lower courts. Okay, so we're going to look at a worksheet and kind of use these worksheets as class notes. These are class worksheets that we would have done in class as more classwork, but as I go through these, just take some notes identifying how the idea of precedence works with Marbury versus Madison, Gideon Wainwright, and Miranda versus Arizona. Okay, so Marbury Madison is the first one I'm going to look at here. Remember, Marbury versus Madison was the case that established judicial review, which ultimately established the power of the Supreme Court, identifying that the Supreme Court's job is to determine whether or not actions of government, laws written by government, are constitutional or not. So we're going to look at these 4 laws that were written by Congress at some point in our U.S. history. They were passed by Congress. They were also signed by the president into law. And then they were looked at by the Supreme Court, and the Supreme Court said, no, you don't have the power to do these laws. Okay, these laws are unconstitutional. So with each of these being determined unconstitutional, we have to decide what happened next. All right. So our 3 options for each is going to be, did Congress change the law? So rewrite it, reword it so it does make it constitutional. Did a change, would a change require a constitutional amendment, but there was not enough support, so essentially the law just died, it just went away? Or was an amendment added to the Constitution, making these laws now constitutional? Okay, so our first example is the Flag Protection Act of 1989, which makes flag burning a crime. Now, usually when I ask this in class, students, I'm under the impression that many students think it is illegal to burn the flag. Technically, it is not, okay? Now, when you see people burning the U.S. flag in public, usually they're probably getting arrested, but it's not for the flag burning itself. It's for, starting a fire, in the middle of a public place. So more of an arson reason that they're being arrested for. Okay, so the Supreme Court said the following. They said Congress could not make it a crime to burn the U.S. flag. Burning the flag is an expression protected by the First Amendment right to freedom of speech. So we went over the Bill of Rights. We identified your First Amendment rights to freedom of speech is kind of like your right to express yourself, your opinions, who you are. So Supreme Court looked at flag burning as that they couldn't make it illegal to burn the flag because that was an expression of your opinions, your views. All right, so what do you think happened next? All right, first option, did Congress change the wording to make flag burning a crime today? Would they have had to change it or make a requirement to the constitutional amendment, and there was just not enough support for an amendment? Or was an amendment added to the Constitution to make flag burning illegal? So we know a couple things. We know there's not an amendment that makes it against the law to burn the flag, so we can get rid of that option. And kind of answered it at the beginning that there is no law today making flag burning illegal. So our option would have been the second option, which says change would have required a constitutional amendment, but there just was not enough support. Okay. And there were several attempts at this. Many times they tried to come up with new rules and new laws to this idea of making flag burning a crime, but there was just never enough support to make a constitutional amendment for it. All right, our second option, B, a line item veto act of 1996. So this would have been during, the first one, 89, would have been during Ronald Reagan as president. This one, line item veto act of 1996, would have been during Bill Clinton's presidency. This would allow the president to veto parts of a bill while passing the rest. So this would have given the president an insane amount of power, okay? So we went through, how a bill becomes a law. Congress writes the bill. Both sides, the House and the Senate, agree to it. They both pass it. So now the bill goes to the president's desk, and then he decides if he wants it to be a law or not a law, all right? Sign it into law or veto it. This would allow the president to just take out parts of the bill that he didn't like. So he could say, I don't like this part. I like this part. Nope, scratch that part out. And then essentially rewrite the bill on his own and then sign it into law. All right, so they gave the president at the time in 1996, President Clinton was given the power to do this. So it went to the Supreme Court. Enough people got behind it and said, you know what, this has to go to the Supreme Court. We don't think the president has the power to do this. It says Congress, the Supreme Court ruled saying Congress could not give the president the power to veto certain parts of a law. The Constitution says the president must sign a law or return it to Congress, not change it all by himself. All right. Congress has to be part of that change, is what the Supreme Court said. All right, so our next option is looking at, well, what happened? All right, in this case, Congress reworded it to make the law constitutional. All right, they basically reworded it to the point where if the president wanted to cross things out of a bill, it would go back to Congress. They would look at the things that the president took out, and then they would have to agree to it in a short period of time, and then it could become a law. So it does give the president the option to veto certain parts of a bill, but Congress constitutionally has to approve those changes the president's making today. Okay. Part C, or Law C, Stolen Valor Act of 2005, says makes lying about military service awards a crime. This would have been during George W. Bush's presidency, and they made it a law. Congress passed it, the president signed it, that said I can't say I was in the military, lying about it. So by me saying, let's say, I told my class one day, yeah, I served in the Marines, okay, and that's a lie. I didn't serve in the military. I'm violating the Stolen Valor Act of 2005, okay, and could be charged with a crime for lying about service that didn't exist, okay. Well, Congress looked at that, the Supreme Court looked at it and said Congress could not make it a crime to a lie about receiving military medal. Free speech means that government can't decide some lies are punishable. All right, so this is very important because it's basically identifying that Supreme Court saying we can't say one lie is punishable, but other lies aren't. All right. So if the Supreme Court would allow this law to stay in place, they basically would have opened up the door to saying, okay, if Congress has the power to make this lie a crime, what's to say they can't make all these other lies a crime? And that's why the Supreme Court ruled in the way they did. All right. They said, you know what? We can't make one lie punishable and not others. So looking at the options then, all right, what happened next? Did Congress change the law to make it constitutional? Would they have needed an amendment? There wasn't enough support, or did they amend the Constitution to make lying about military service a crime? What they actually did is they went with the first option here. Congress did make a law. They changed the wording of this to make it constitutional. Essentially, what they did is they made the wording so you can't profit from it, all right, from the lie. So if I say, yeah, I was in the military, okay, I can lie about that. I'm not going to be punished. But if I'm saying I'm in the military and gaining from that, I'm getting financial gains from that. I create a GoFundMe account or page, let's say, and I say, I'm a military vet. I earned these medals while I was in the service, and I'm down on my luck, can't find a job. Please help me. And people start donating money to my GoFundMe. That would be a crime. I can't lie about my military service to gain financially in that way. Okay, so there is a law, but not to the extent that it was originally written. Okay, and the last one, Voting Rights Act Amendment of 1970 requires states to change the voting age from 21 to 18. Now, this is important. This one's kind of a tricky one. Okay, you got to remember back when we covered the powers of the federal and the state levels, so that idea of federalism. When it came to voting powers, those powers always remained with the states, okay? The states had the power of elections, whether it was, besides the date of the election, the November date is always going to be in the Constitution. The first Tuesday after the first Monday in November is when our election is going to take place. That's in stone, but after that, it's up to the states how they operate and run the elections. So in this case, age requirements could not be determined by U.S. Congress. They would have had to been determined state by state. And that's what the Supreme Court ruled. They said the Constitution does not give Congress the power to make rules about state and local elections. Congress could not give 18-year-olds the right to vote in these elections. So it was a state-by-state issue. So essentially, you could have some states having it 21, and other states having laws in their own states where you could be 18 to vote. So each state would have been slightly different. Thinking back to like when women got the right to vote, it was the same thing. Some states were allowing women the right to vote. Some states were not allowing women the right to vote. So in that case, it had to go through the amendment process. An amendment to our Constitution had to be added to give women the right to vote. And it'll be the same thing here. Because Congress didn't have the power to make these laws, a constitutional amendment had to be put in place in order to give 18-year-olds the right to vote. Okay, so those are just some examples going through how the Supreme Court uses the idea of precedents. You know, they set a standard, and they're going to make sure they're going to check the a check of power of the Congress and the presidency to make sure that laws that they're writing and passing are not violating constitutional rights. Okay, so let's go to the next one. Gideon versus Wainwright. All right, this is going to look at, Gideon Wainwright had to do with amendment rights. Okay, so what type of amendments in the first 10 amendments in the Bill of Rights apply to different things. Okay, so we just want to identify, in this one, we're going to identify, we got our list of amendments here, First Amendment, Second Amendment, Fourth Amendment. So we're going to look at which Supreme Court case dealt with what amendment. Okay, so the first one says, Neer versus Minnesota, 1931. So these are some old cases, but they set the precedents for how all future courts have to rule. It said Minnesota passed a law saying scandalous newspapers could be shut down. J.M. Neer published a paper that was shut down for running stories about police corruption. All right, this one should be pretty obvious. We're going to go with First Amendment right. Freedom of the press. Okay. And obviously, we do not want our cities or states or federal government, local governments, we don't want any level of government being able to shut down a newspaper that's trying to inform the people about what's going on just because someone in local government doesn't like it. Okay. Letter B, In re Oliver, 1948, was a Supreme Court case where a Michigan judge investigated a crime by calling in witnesses to testify in secret. So there's our key word. It says in secret. Oliver testified, but the judge didn't believe him. Still acting in secret, the judge punished Oliver by sentencing him to 60 days in jail. So in our Constitution, your Sixth Amendment rights give you the right not just to a speedy trial like the one says above, but to a public trial, meaning that when you're put on trial, the public needs to know that you're on trial. All right, they have to tell you that it has to be publicized that so-and-so is being arrested and being put on trial. In this case, this guy, Oliver, was sentenced to jail for 60 days in secret. So no one even knew where he was. Imagine being his family. Oliver disappeared. He was put on trial in the secret trial and then put in jail for 60 days in secret. Letter C, McDonald versus Chicago, 2010. The city of Chicago passed a law banning all handguns. McDonald and others can no longer keep handguns in their homes. That should be an easy one. It goes with your right to bear arms, Second Amendment. All right, so in this case, Chicago did pass a law banning all handguns, but this was considered unconstitutional because your Second Amendment right gives you the right to bear arms. Now, the city of Chicago can create legislation to make it harder to own guns or legislation that's going to make you jump through more hoops to own a gun, or not allow, like the city of Chicago, in the city limits, you're not allowed to have shooting ranges and stuff like that, let's say. So businesses can't do that, but they can't just tell you can't own a handgun, especially for those that had one before. The city of Chicago can't come knocking on your door and ask you to turn over the gun that you had bought prior to some of those legislations and laws being put in place. Okay. Letter D, Cloper versus North Carolina. Mr. Cloper was charged with criminal trespass. After a mistrial, his case was put on hold indefinitely, but could be reopened at any time. So this would go with your Sixth Amendment right to a speedy trial. All right, so in your Sixth Amendment right, you have the right to a speedy trial. You can't be held for years, or you can't be told, well, you might be tried for that crime, but we don't know yet. All right. If you're arrested, you're accused of a crime, that trial has to take place in a reasonable amount of time. You can't be, sitting there. You imagine in this case, in 1967, this guy's just sitting at home wondering if this case is ever going to be reopened. Is he guilty? Is he not guilty? And just always wondering that in the back of your head. They can't hold that over you. Letter E, Benton versus Maryland. It says, at the trial, John Benton was found guilty of burglary, but innocent of larceny. But the jurors had been chosen unconstitutionally, so he was offered a second trial. He was charged again with burglary and larceny. Okay, so this is that double jeopardy one that we went over. You cannot be tried for the same crime twice. Okay, Once you're found not guilty, or if you're found guilty of one crime, let's say, but if you're found not guilty, you cannot be charged for that crime again. Okay, like I said in class, I know it sounds odd, but you could be found not guilty of murder. You can come out of the courthouse, say I did it, point to where the body is hidden. You cannot be tried for the murder again. You can be tried for other things in connection with that murder. So no one's ever going to probably do that, but you can't be tried for the murder. All right, next one, Mapp versus Ohio. Police forced their way into Delray Mapp's house looking for a fugitive. So they came in looking for a fugitive. They didn't find the fugitive, but they did find a box of inappropriate books and photos. They took it and used it to convict Mapp of possessing obscene material. So at this time in Ohio in 1960s, I believe it was some form of pornography or some sort, and it was against the law at that time to have that type of material in Ohio. So they were looking for a criminal, but while they were looking for that criminal, they saw something that was illegal in his house. So that's where the problem was. And this went to the Supreme Court, and this would be a protection from your Fourth Amendment right from unreasonable search and seizure. All right, so there's got to be within reason. They can't go searching through other stuff or through boxes if they don't have the proper warrant to do so. Okay, and then the last one, I know it's kind of out of the picture. It says Benjamin Glitlow had been convicted of a crime in New York for distributing pamphlets about his extreme political beliefs. So that's just an easy freedom of speech. All right, it's your view. You have your own political beliefs. People might not agree with you, but you have the freedom to express your opinion in that speech. That's kind of the beauty of our First Amendment, all right? And maybe the downside of it is usually our First Amendment right to freedom of speech is protecting the speech of those majority aren't going to agree with, okay? Because if you take that person's right away to express themselves, that's opening the door to take everybody's right of expression away, okay? And then the last one I'll look at real quick with you guys is the Miranda versus Arizona case that we went over. All right, Miranda versus Arizona, remember, is the case that identifies your Miranda rights, okay? So I'm just gonna go down these kind of quickly, identifying, why is the Miranda warning important? This is your Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in the court of law. The third part says you have the right to talk to a lawyer and to have a lawyer present with you while you are being questioned. The fourth part says if you cannot afford to hire a lawyer, one will be appointed to represent you for any questioning if you wish. And then the fifth part of the warning is you can decide at any time to exercise these rights and not answer any questions or make any statements, okay? So these are just reasons why the Miranda warning is an important piece, an important Supreme Court case, because this established when I'm being arrested, what type of rights do I have, okay? Now they established this Miranda warning because they said, prior to this case in 1966, it was just assumed that you better know your rights when you're being arrested. This case kind of established not all Americans are going to know their rights, so it's the police's responsibility to identify what your rights are, let you know what your rights are. Okay, so let's just go down the list here. It says when seeking justice, officers must not take advantage of the fact that someone has low income. So this will go with part 4, that if you cannot afford an attorney, one will be provided for you. Second important piece is some people might not know they have the right not to speak to the authorities. So that's in that introduction, you have the right to remain silent. All right, some people are just going to be under the impression that, hey, I got this police officer, these detectives talking to me, I need to tell them stuff, I need to talk. All right, you have to tell them basic things that they ask you, your name, where you live, your birth date, your age. You could be in contempt and be arrested for not answering those basic questions, but when it comes to it, question you about a crime that they think you may have committed, you have the right to plead the fifth, as they say, right to remain silent. Having a lawyer present during questioning helps protect a person's Fifth Amendment to remain silent. So like it says in part 3 here, you have the right to talk to a lawyer. Next one, a person needs to understand not just the basic right, but also the consequence of not exercising that right. That'd be part 2. Anything you say will be held against you in the court of law. If at any point the person says they don't want to talk, any statement taken after that after that must have been forced. So that's at the very end where it says at any moment you have the right to exercise these rights. You can kind of listen to the questions and see what they're kind of feel it out if you really want to. And at any point you can say, all right, I'm done. I plead the fifth. I want a lawyer. Next one, being reminded of the basic right makes a person less likely to give up their right if investigators make it seem like the silence proves the person is guilty. So this is just that first part of the amendment, Miranda warning. You have the right to remain silent. Next one, someone could think the right to talk to a lawyer means only if you can afford to hire one. All right, so this would go with that fourth part again, that if you cannot afford a lawyer, one will be provided for you. Call those public defenders. So it was after 1966 case of Miranda versus Arizona when that job of a public defender really came about. That you see if you watch your Law and Order, Criminal Minds type shows, those public defenders are used a lot. Next one, it helps people realize the questioning is a stage of the legal system and officers are not on their side. So this would be part 2. Anything you say can and will be used against you in a court of law. Okay, not really like that point where it says the officers are not on your side. I mean, they're trying to find the truth, so they're going to question you to the point where they're trying to figure out, are you guilty or not guilty of this particular crime? Okay, a lawyer can help make sure any statements made to law enforcement are accurately reported during a trial. So this would be part 3. You have the right to an attorney, a lawyer with you. And the last one, telling someone the basic right up front lets that person know the authorities recognize that their rights exist. So this is right at the beginning. The authorities, the police are going to tell you, you have the right to remain silent. Okay, so those are the 3 worksheets that we would have done as classwork. Hopefully you watched through this video to kind of identify and understand the importance of these cases, why the Supreme Court is so important to our system. It's kind of, I always think of it as a forgotten branch of government because we always know about the executive branch and the president, the legislative branch and how Congress makes the laws, but we often forget how important the judicial branch is to ensuring that the other 2 branches' power isn't stepping on our rights. And once the Supreme Court rules on a case, that really sets the standard going forward for American citizens. Okay, if you have any questions, feel free to reach out and let me know.